Welcome to the Kelley Consulting Firm's presentation on discrimination and harassment. Our agenda for today's presentation includes a brief introduction. We're going to discuss what is discrimination and some of the theories of discrimination. Then we're going to discuss harassment, retaliation, and if we have time, we're going to go over a few case studies. My name is Dr. Robin Kelley, and I have over 20 years experience working in human resources, management consulting, equity, diversity, and inclusion, equal opportunity, employee relations, and I have been an independent consulting since 2015, and I started Kelley Consulting Firm. Well, let's get into the presentation. What is discrimination? Discrimination is conduct that can include a broad spectrum of disparate treatment directed towards an individual or group of individuals based on a protected class that adversely affects their employment or education. Discrimination includes denial of requests for reasonable accommodations based on a disability or religion. I mentioned previously that discrimination is adverse treatment based on a protected class or protected classes. The protected classes include race, color, religion, national origin, sex, gender identity, age, disability, veteran status, genetic information, sexual orientation. Now, these are the federally based protected classes. Each state may have additional protected classes, but for the purpose of this presentation, we're going to just list the federally protected classes. Next, we're going to talk about the theories of discrimination. And the theories of discriminations are the framework for any investigations or any complaint handling. There are primary theories of discrimination. Disparate treatment is when an individual is treated differently or less favorably because of their protected class. Disparate impact is a policy, practice, rules, or other systems that appear to be neutral but result in a disproportionate impact on a particular protected group. Harassment is when an individual has been subject to unwelcome conduct based on their protected class. Accommodation is when an individual needs to be treated differently because of a disability or religion and they're not. Retaliation is any adverse action against an individual because that individual engaged in a protected activity. So for example, filing a complaint, a request for a reasonable accommodation would fall under this category. The overwhelming amount of complaints that fall under discrimination fall under disparate treatment. And disparate treatment, to establish a case for disparate treatment, a complainant must establish what we call a prima facie case of discrimination. Then the employer must articulate through admissible evidence a legitimate non-discriminatory reasons for his action. And then in order to prevail or for the complainant to prevail, the complainant must prove that the stated reason is a pretext or a mask to hide the true reason, which is discrimination. So how does a complainant establish a prima facie case for discrimination? Well, the complainant must be a member of a protected class, and a protected class, as I mentioned earlier, falls under race, color, religion, sex, age, national origin, disability, genetic information. That's the first prong. And this is typically self-identified. Then the complainant must demonstrate that they experience an adverse action. So some examples of an adverse action is academic action, such as someone, receiving poor grades or not receiving an award or receiving negative recommendations or evaluations, or, failing to provide an otherwise reasonable accommodation for a disability or religious belief can be considered an adverse action. That is the second prong. And then the third prong is a similarly situated individual of a different protective class than what the complainant is saying that they are, was treated more favorably than the complainant. So the three criteria for establishing a prima facie case of discrimination is the complainant is a member of a protected class. 2, they suffered an adverse action. And then 3, a similarly situated individual was treated more favorably than the complainant. Establishing a case for disparate treatment. I had mentioned to you before that for a complainant to establish a prima facie case of employment discrimination, the complainant must demonstrate that they're a member of a protected group or class, and the complainant was subject to some adverse action. And then 3, that a similarly situated individual was treated more favorably than the complainant. Then the burden shifts to the employer. The employer then has the burden to articulate some legitimate non-discriminatory reason for its actions. So, for example, if the complainant failed to receive a raise and the complainant filed a complaint saying I was discriminated against, the employer then has the burden to articulate some legitimate non-discriminatory reason. So, for example, the employer comes back and says, well, the reason why the complainant didn't receive a raise is because she had a poor performance evaluation. And that would be a non-discriminatory reason or an example of one. Well, then the burden shifts back to the complainant, and the complainant must show by a preponderance of the evidence that management's stated reason is actually pretext or a mask for discrimination. And so, say the complainant comes back and says, actually, John Doe, who is male and I'm female, received a poor performance evaluation as well, but he received a prorated amount of his raise. And so he received a raise, but I received nothing. So that would be an example of, providing evidence by the complainant that the actual stated reason by management was actually pretext or a mask for discrimination. Many times in disparate treatment cases, they can be proven or show or demonstrate disparity using statistical evidence. So, for example, if females file a complaint of a lack of promotions and raises, then during an investigation, the investigator can take a look at, or management or the person charged with handling these types of cases can take a look at who's been promoted in the past however many years and the raises, and look at it and see if you can find any disparity between males and females, for example. So statistical data can also be used as evidence to show disparate treatment for a particular class. Establishing similarly situated individuals. And I'm going to discuss Title VI as well as Title VII. Title VII includes employment, but Title VI includes students and educational institutions, and they pretty much have the same application for looking at these types of cases. So, establishing similarly situated individuals. Well, similarly situated is any individual in comparable situations or when circumstances are nearly identical. What to consider? Same supervisor? Are they in the same department or unit? Are they subject to the same performance standards? Are they subject to the same policies? For students, do they have the same professor? Are they in the same class? Do they have the same major? And then for both employees and students, do they have the same, or are they subject to the same disciplinary standards? Establishing legitimate non-discriminatory reasons. Respondents' reasons, and a respondent is someone who a complaint has been filed against, like management, supervisors, or an organization or institution. So respondents' reasons must be sufficiently clear and specific enough for the complainant to respond and to offer rebuttal evidence. Examples of insufficient reasons that wouldn't fall under non-discriminatory reasons. Sam failed the course because he didn't do a good job on his project. That's not telling you anything about the reasons for someone failing. Or look at the second example. Ashley did not need the accommodation she asked for. With no other explanation, this is a response. So that is not considered sufficient reasons. The investigator's job is to probe for specific answers when vague answers are provided. And I would say also you should have a policy that indicates whose job it is to kind of do the investigations and get these answers. And so these wouldn't fit the requirement for establishing a legitimate non-discriminatory reasons for any adverse actions that may have happened to a complainant. I just want to touch briefly upon disparate impact and the analysis of those cases. You may recall earlier in this presentation, I mentioned that disparate impact is a policy, practice, rule, or activity, for example, that is neutral on its face, but has the result of having a negative impact on certain protected classes. And in analyzing a disparate impact case, the first step is to really take a look at whether the policy, practice, or activity and the methods of administering the policy, practice, or activity adversely or negatively affects members of a protected class. And so take a look at the policy at hand and then take a look at both the policy, practice, or activity and in and of itself, and then take a look at the administration of it, because there could be something within the administration of it that could be adversely affecting the members of a protected class. When looking at disparate impact under Title VII, it's pretty clear cut. Take a look at it. Some cases are a little more complex, but generally identify the specific policy or practice at issue. Establish if there any harm or damage done already through the policy or practice, and then establish disparity, so unfavorable treatment. So in this part, you may be doing a comparison, right, between women and men, or certain racial minorities and non-minorities, for example, abled and disabled individuals. So establish disparity of unfavorable treatment. And then lastly, establish a causal connection. Can you establish directly that, for example, your recruitment policy has a negative effect on disabled individuals because it doesn't provide for accommodations for individuals putting an application to your institution, as an example, where there may be a causal connection there. Surprisingly, certain discrimination may be actually legal. So when sex, religion, or national origin are considered a bona fide occupational or BFOQ, what this means is that, for example, you need a locker room attendant and it's for a female, for example. There may be a need to hire a female for that particular job. Or, for example, a men's identified restroom, you may be able to seek a male for that position. Those are some examples where sex, religion, or national origin are considered a bona fide occupational qualification. I must say, when you think about this qualification, race will never fall under a BFOQ. So pay attention to the protected classes where it may be permissible to recruit or hire for particular individuals. And then secondly, when work-related requirements are considered a business necessity. So you may have a business necessity in terms of someone being able to lift something, and it may be a business necessity for that. But you have to be careful with those types of things. Most of the time, where you may see a work-related requirement may be we need you to you're hiring someone to preach for Jewish services, for example, for your staff, and so you may need someone that's Jewish or identifies as Jewish, may fall under this category. Third, seniority systems provided for in collective bargaining agreements may make it legal to discriminate against someone, where seniority systems have been challenged in the Supreme Court, and it's been upheld that seniority systems that may appear to be neutral through a collective bargaining agreement may be discriminatory towards certain racial groups because they weren't in the workforce as long, as non-maybe racial minorities, but it's permissible because the courts don't want to, and especially the Supreme Court, they don't want to get into bargaining contracts that were faithfully executed or bargained between management and the unions. And so sometimes this is considered, or most of the time is considered, legal discrimination, even though it may have a desperate impact on a certain group. Transitioning to harassment. So harassment is considered to be a form of discrimination, but it has its own separate definition from discrimination. Harassment is unwelcome conduct that is based on race, color, religion, sex, including pregnancy, national origin, age, so anyone 40 and over, disability, or genetic information. Harassment becomes unlawful where 1. Enduring the offensive conduct becomes a condition of continued employment, or 2. The conduct is severe or pervasive enough to create a work or educational environment that a reasonable person would consider intimidating, hostile, or abusive. Retaliation. Anti-discrimination laws also prohibit harassment against individuals in retaliation for filing a discrimination charge, testifying, or participating in any way in an investigation, so think witnesses, proceedings, or lawsuit, or opposing employment practices that they reasonably believe discriminate against individuals. Most recently, the EEOC, the Equal Employment Opportunity Commission, mentioned that they had findings in retaliation cases overwhelmingly, even when a discrimination or harassment case failed on its merits. So they take retaliation cases very seriously. I already established that discrimination and harassment statutes cover employees, and students are covered under Title VI of the Discrimination and Harassment Statutes. But I want to point your attention to a landmark case, Robinson versus Shell Oil, which was decided in 1997. Whereas Mr. Robinson filed a discrimination lawsuit alleging that Shell Oil Company fired him from his sales position on the basis of his race, and he identified as black. During the pendency of his lawsuit, Mr. Robinson applied for a position with another company. The company reached out to Shell Oil Company for a reference. Shell Oil provided a negative rating for Mr. Robinson and indicated it would not rehire him. So someone at Shell Oil who was responding to a reference check by this company and answering the typical questions, how would you rate this person's performance? And if you had a chance to rehire him again, would you? And Shell Oil responded in the negative. But Shell Oil argued that Title VII did not apply in this case because Robinson was a former employee. The big question for the Supreme Court was, are former employees protected under Title VII? And what the Supreme Court found or determined is that Title VII's prohibition against retaliation also protects former as well as current employees. And this is considered a game changer. So even a former employee is protected from retaliation. And that is the most important thing I wanted to point out to you in this presentation. Now we're going to transition into a few case scenarios now that you have some of the basic underlying information. The following cases are actual cases that I have been a part of. A few names and situations have been changed to protect the innocent and the guilty, but I think it will be a good basis for you to understand the concepts and work out a few case studies. The inappropriate professor. Zaina is a Lebanese graduate student working in a research lab with Dr. Richards and other graduate students. Dr. Richards is Zaina's immediate supervisor. Zaina has been the subject of several racial ethnic comments and inappropriate sexual comments by Dr. Richards. Being the only female in the lab, Zaina was often made to work in a separate rear office while her male counterparts were allowed to work in front with Dr. Richards. Once when Zaina attempted to spell a word for a fellow graduate student, Dr. Richards interrupted by stating, "This is America, not Lebanon." On another occasion, Dr. Richards asked Zaina if she was wearing a bra and commented that she was looking good. Dr. Richards commented that he wondered what her body looked like underneath all those clothes and asked if Zena ever gets hot. One day, when Zena was going out for lunch, she asked if anyone wanted her to bring something back for them. Dr. Richards started naming a large amount of food. When Zena asked Dr. Richards how did he expect her to carry all those items, he responded that she should carry it on her head since that's what Arabs do. The most recent inappropriate interaction between Dr. Richards and Zaina included him telling her that she could not attend a department social event because it was only for Americans. So, what's next? Well, Zaina couldn't take Dr. Richards' comments and treatment anymore. She went to her dean to complain about Dr. Richards. And ultimately, in this case, she actually filed a formal complaint with her institution's equity office. And to make a long story short, Dr. Richards ended up being reprimanded in this particular case, and he was found to be responsible for several different areas of discrimination and harassment of Zaina. How about this next case? Sleepy Town, USA. Gina is the lead manager for ABC Nursing Home. The home serves 10 developmentally disabled clients who require 24-hour direct care. One night, Gina, the second shift supervisor, returns to her office at 10 p.m. to pick up some forms. When she walks into the break room, she finds staff member Calvin asleep in a chair and another staff member, Amy, is nowhere around. Moments later, Amy walks through the door with bags from a fast food restaurant. Amy claims she took out the trash and left for a second to get food. Gina thinks Calvin is lazy and does not like him. Gina gives Calvin a letter of reprimand for sleeping on the job and for leaving patients unattended. Well, come to find out, Amy was gone for approximately 35 minutes, which is much longer than a second. Despite this, Gina decides not to give Amy a written reprimand for leaving patients unattended. Gina likes Amy and wanted to give her another chance before starting any formal disciplinary process. She talks to Amy but puts nothing on her record or in her personnel file. Calvin and Gina have the same title, duties, work the same shift, and have the same supervisor. Calvin files a complaint alleging that Gina discriminated against him because he's of a different race than Gina. What do you think? Will Gina's company prevail or be liable for her decision to discipline Calvin? I can say in this case that her company may be liable or end up being liable for Gina's decision. You have the three prongs that are needed for establishing a prima facie case of discrimination. And Gina did not provide any legitimate non-discriminatory reason other than, she treated Amy because she liked her and didn't want to start a formal process with her, and that she wasn't too fond of Calvin and she thinks that he's lazy. So I think her institution would, in this particular case, have a very difficult time prevailing based on her decision. Okay, we're at our last case study entitled Party Invitation. A Facebook posting advertising Monday's Compton Cookout invited people to a condominium complex off campus. The invitation urged all participants to wear chains, rapper-style urban clothing by makers such as FUBU, and speak very loudly. Female participants were encouraged to be ghetto chicks with gold teeth, cheap clothes, and short nappy hair. The invitation said the party would serve watermelon, chicken, malt liquor, cheap beer, and a purple sugar water concoction called Dat Purple Drink. The party was organized by members of several university fraternities. This is actually a true story, and this is not a case that I actually worked on, but I have used it in presentations. And this one's a little tricky because it happened off campus, and the invitation was on Facebook. And if you're a public institution, you may have additional protections for this because of free speech for faculty, students, and staff. But if you don't have policy language prohibiting some of this may be just a poor um, thing for the person who put this out on Facebook to do or party to have. But it speaks to your overall culture and what you want to do. So while it may not be against the law and it may not be prohibited by your policy, it may be something that you want to address in terms of the culture and climate of your institution and take a look at your policies and see where you may be able to dissuade people from engaging in this type of activity. What actually happened in this case is that other students, faculty, and staff at the university in question did not find this to be funny, amusing, or something that the school shouldn't do anything about. There were a number of protests and meetings between students and administration. There were public statements made by the president. And so it turned into a big issue where the university agreed to kind of take a look at their policies and procedures and practices and do things to improve the environment for underrepresented students and African American and Black students in particular. Thank you. That's the end of our presentation. But I want to express that on the next few slides, you'll find additional information about Kelley Consulting Firm. At Kelley Consulting Firm, we provide a number of services, including consulting, training and organizational development, assessments and studies, culture studies, discrimination and harassment, compliance, diversity and inclusion. We conduct investigations, including EEO, Title VII, Title VI, Title IX investigations, sexual harassment. We also do mediation and alternative dispute resolution, where we can come and actually do the mediations or alternative dispute resolution processes, or we can help you set up your own process. We conduct strategic planning and program initiatives. What differentiates Kelley Consulting Firm is that we're a woman-owned small business, a woman business enterprise, an economically disadvantaged woman-owned small business. We also have certifications in equal employment opportunity investigation, senior professional in human resources through HRCI. We have a certificate in diversity management, Title IX Administrative Coordinator Certificate, Women's Leadership Forum Certificate, Equal Employment Opportunity Commission EEOC Certificate. We have Trauma Informed Investigations Certificate, over 20 years experience, and Mediation Certificate. If you like this Kelley Consulting Firm video, give us a thumbs up and or subscribe to us on YouTube. You can also follow us on LinkedIn, and there's the listing right there on the slide, or on Facebook, and there we are on Instagram.